Hello, and welcome to Timing is Everything, a program of Care Dimensions. My name is Mary Crowe, Director of Professional and Community Education at Care Dimensions. And I'm thrilled today to once again, we do this yearly actually with Arthur. This is Arthur Skarmeas, and he is an attorney out of Topsfield. And I love talking with Arthur about advanced directives. And April is National Healthcare Decision Month. April 16th is actually National Healthcare Decision Day. So this is such an important topic. I know we kind of focus on this, Arthur, in April, but boy, this is this is something we need to be talking about year round. So thanks again for being on the show today.
Happy to do it. Seems like it was just yesterday that I was here before. But,
it does, doesn't it? I'll tell you.
I just realized National Healthcare. What is it? National Healthcare Day.
Decision Day.
Decision Day is pretty much the same as Tax Day. So whenever you file your taxes, you should also be thinking about making your long-term care decisions.
Love it. That's a great idea. Great idea. So just tell people a little bit about yourself before we dive in today.
So I've been an attorney for 38 years now, and I have a practice up in Topsfield. We do a lot of estate planning, which includes healthcare, proxies, power of attorneys, wills, trusts, whatever somebody needs to make the decisions to take care of themselves and also their family members as they get older, and in case something unexpected were to happen. So that's really what we specialize in and what we've been doing for a long time.
Excellent, excellent. So, I'd always like to start with kind of really defining, because people hear this term advanced directive all the time and they really may not understand what that means. So can you define that for the audience?
So an advanced directive is oftentimes also known as a living will. And it is a document that is something that will provide your wishes in the event that you were to be in a situation where you really had where you're essentially in a irreversible coma or a brain dead situation where you have no hope of recovery, and it's a instruction that really says that you don't want to be kept alive by artificial means, and that you want the machines to be taken off and to allow yourself to pass away in that particular situation. So it's a very specific document. It has very specific purposes. It sometimes is confused with, it can be confused with a general healthcare proxy. It can be confused with a DNR. Those are totally different things. But this is really for that extreme situation where you've suffered some type of an illness or injury and you don't have any ability to recover and resume any type of normal life.
Yeah, and I always like people to understand this because, it's almost a little bit of an umbrella term, isn't it? Because we're talking about legal documents today, and under that legal document that you put in place in advance of making your wishes known when the day comes that you can't do that for yourself. I always like to say and we'll talk about this when we talk about the healthcare proxy, about when we're appointing an agent, it's somebody not making decision on our behalf, but really being our voice. So when we're talking about these documents, and you're speaking about that living will piece, so we're talking about healthcare proxies, durable powers, and living wills. And we'll get into that living will, right? Because even though living wills aren't legal in the state of Massachusetts, they're an important guideline, right?
Yeah, so Massachusetts may be the only state that actually doesn't have a specific living will statute. But nevertheless, if you have executed a living will or an advanced directive, that will be useful as two things. Number one, to the people that are taking care of you, it's your direction to them, and they can rely upon that in making that determination as to whether or not to take off life support. And secondly, if there's ever a dispute, and there certainly have been cases in various jurisdictions all over the country from time to time, some of them become famous cases. But if there's a dispute between somebody in the family wanting to take off life support and somebody not wanting to take life support away, the statement that you've made in that document is evidence, and it's evidence that can be considered and will be considered by a court as to what you want to do in that particular situation. So while we don't have a specific statute that authorizes with the force of law the living will in Massachusetts, it is a document that is still needed and effective and very, very useful in the state of Massachusetts, as far as making sure your those types of wishes are known and will be followed.
Okay, great. And so let's talk about like again, breaking these up into categories. Let's talk about the healthcare proxy is so important, Arthur. And I'll have people say to me, geez, I can't do a healthcare proxy because I can't afford it. I can't do a healthcare proxy because, well, I'm in good health. I don't need to do one. I don't have to do one because my spouse will be able to make those decisions. My children, my adult children, these are the things that I get, people say to me all the time, not understanding. And what's interesting is, and we talk about this even after, and we're living through a pandemic, and still only about a third of the population has a healthcare proxy complete. So can you talk about the importance of a healthcare proxy and answer some of those questions that I posed?
Sure. So a healthcare proxy is a document that is allowed by statute in Massachusetts, as it is in pretty much, I think, every state in the country. And that is the document that gives authority to somebody to act for you in all healthcare decisions when you are not able to make your own decision. So it only comes into effect when you have been determined by the medical people that are treating you that you cannot make a rational, reasonable, thoughtful decision relative to your own health care. Sometimes that's obvious. You may be unconscious. You may be under medication. You may, or sometimes it may be a little bit less obvious. People that are older and have dementia or Alzheimer's, at some point along that road, you're not going to be able to make decisions for yourself anymore. But the medical professional is going to be the one that says that we're invoking the healthcare proxy. And when that is done, whoever you have chosen will now be the person that will be able to make your healthcare decisions for you. But not only that, they'll be able to get all of the relevant and necessary information relative to your condition at that particular time. Any records that are needed, a full information from the doctors that are treating, and without that, the privacy laws will prevent you from getting that information. So not only will you have nobody that's able to make a decision, you won't even be able to get information as to what's going on, and that can apply to spouses.
Yes.
So, I mean, I've seen it go both ways. Sometimes medical professionals will still talk to the spouse. They'll just say, "Okay, you have a healthcare proxy, right?" And they're going to take the opportunity. They're going to take the chance of maybe violating HIPAA to some extent for expediency, but not always. And technically, they don't have to and probably shouldn't. And in that particular, so if you don't have somebody and you're in that situation, really the only alternative is to go to probate court and get somebody appointed as get yourself or somebody appointed as a guardian to be able to make those decisions. And that's not optimum because the probate courts go at their own speed, even in emergency situations. They're never going to go as fast as you want them to go. B, it costs money to do that when doing a healthcare proxy is very simple and cheap. And quite honestly, if you a lot of times, if you're in a hospital or a doctor's office, giving away the secret, but there are forms that you can fill out to do that. Okay. They may not be, the perfect document, but they're sufficient. But if you don't have one, then it's going to take time, it's going to take money, and it's going to be a lot of aggravation to get somebody appointed to be able to act for you. And that's not something that you want, and it's something that can be easily avoided by having just having a healthcare proxy. And they're easy
Absolutely.
to do, they're simple to do. You pick who you think you want you pick who you want to have as your healthcare proxy. You can add a secondary or a third choice And once that's in place, it's going to be followed, and you're protected in that situation.
Yeah, excellent. And that's, so really, like you said, listen, it people can do it at no cost. Sometimes people, when they're doing their other documents, they'll go to, and I do want to say, because you had mentioned this earlier, when you are utilizing an attorney for this, please please seek out an attorney who is well versed in elder law or estate planning. Sometimes people are utilizing attorneys that aren't well versed in this, like this is a focus that you do. And really, you don't want them to dabble in this, because these laws change all the time. So I like people that, when they're keeping up on this stuff, to really make sure that they're aware of that. So, and they can do one in that situation too. Like you said, though, I think one of the worries is for people, I don't want to sign a healthcare proxy. Here's another worry or a barrier, right? They can come up because people feel like they're losing control once they sign it. But as you mentioned, they're not, because that person, and the proxy is the form, it's the agent that you're talking about, because people will say, oh, I'm their healthcare proxy. No, you're listed as their agent, but the form does not go into effect until you've been determined, like you say, by healthcare professionals to lack capacity, and it has to be then activated. So you're not losing control.
Correct. You always are going to have the ability to make your own decisions, as long as you can make your own decisions. And a lot of times the healthcare proxy is invoked only temporarily. So somebody is in an accident, and is, maybe unconscious, or has been provided with medication that does not allow them to, for that particular moment, make a decision. So now at that time, in that emergency situation, you have the appointee, the agent, that can make the decisions necessary for you for that particular time. But as soon as you regain your ability to make decisions, it's back to you.
Right.
So you're always as long as you have the capacity to make a decision for your own healthcare, you're going to make it. This is only for those times when you just can't. And like I said, a lot of the time it's temporary. Now, of course, you have people with, again, the most common is dementia or Alzheimer's. Once you reach the point where it's going to be invoked permanently, because you've lost your capacity to make those types of decisions. But at that point in time, again, you wouldn't be able to do it anyway. So you definitely, as long as you can make decisions, you have complete control, and you can always change your healthcare. Like, if you can always change these documents. So if at some particular time you want to replace somebody that you have with somebody else, it's easy to do. Somebody may move to a different part of the country, and you have another person that's local that you'd rather have do it. Whatever it is, the healthcare proxy, as with any documents that you do in the estate planning world, can be always changed, as long as you have the ability to make decisions.
Yeah, and people should be updating these as there are changes in their lives anyhow, because again, they might appoint somebody, like you say. And I do like that you had pointed out too, you're going to have a principal agent, but you really should put an alternate, because I have had, when I was doing direct patient work out there, I had many times when the person who they appointed predeceased the person who appointed them. And then again, if they're left with no alternate, again, you're going to be stuck with the guardianship piece if you lose capacity.
Yeah, if you have a healthcare proxy, but you don't have an agent that can do it, then you don't have a healthcare proxy. So,
correct.
So I always tell clients to at least have a backup. I mean, there are a few people that simply don't know who they would want as a secondary, and that's fine if that's the situation. But I do always urge them to, if they have somebody else that they know that they can rely on and trust to make decisions for them, to put them in that backup situation. And a lot of times we'll even add a third person.
Yes.
So so everything is in there, and if something happens to one, you have somebody else that's available and appointed to do the job. So you always want to, again, just as what I always say is that when I'm working on any type of estate planning work with clients, a lot of times we're doing wills and trusts or whatever it is, but I always want to add the healthcare proxy, the durable power of attorney, and I always say that they are the most simple documents that I do, but can often be the most important documents when you have an emergency and unexpected situation.
Yeah, absolutely. And people need to understand, everybody 18 and over should have one of these. So we shouldn't be dealing with only 30% of the population. Everyone 18 and over should have it. When you're 18, you are considered a legal adult. And so everybody should have one of these. So,
Yeah, so just on that, I would say, a lot of times people think about it only in terms of older people.
yes,
But if you have kids and the kids are over 18 and I was talking worst case scenario in my world, but if one of your kids was in an accident and they had to go to the hospital and they were again temporarily unable to make decisions, you as the parent can no longer come in and make decisions for them. It's they're adults now, and the eight, once you're 18 and older, they should have one also. So yeah, anybody that's 18 or older should have a healthcare proxy. Obviously, the younger you are, the less likely you are going to need it, but you never know what's going to happen. And so it's something that, I think everybody should have.
absolutely. And I tell people all the time, really, how these came about with those landmark cases of Karen Ann Quinlan, Terry Schiavo, Nancy Kruzan, and they were all in their 20s. So we kind of put this at, it's for people who are older and frail and such, but we know that these things can happen at any age. I also like to say to people, Arthur, is pick your healthcare agent with your head and not your heart. I think sometimes people feel like they have to choose a person who's closest to them. That's not always the case in terms of, again, you want to make sure that your wishes are honored.
Yeah. So obviously everybody, sometimes a client will say to me, who should I pick? Now I can't answer that question for them,
Right.
but you have to just think about what the person's going to do. So the person is going to be making your healthcare decisions in your best interest at any particular given time. So whether that be to have a procedure or to take a medication or something more serious, whatever it may be, you want to take the person that probably knows you the best as far as that is concerned, and also is comfortable doing that, because some people aren't comfortable
Right.
making healthcare decisions for another person. And you also obviously have to talk to the people that you are putting on these forms and make sure that they're fine with that, because going back to what we said before, if the person, just because you appoint somebody doesn't mean they have to do it. And
Right.
so if you do a healthcare proxy and you say that, your daughter is going to be the healthcare proxy, and then something happens and the daughter says, I don't want to do it. I'm not comfortable doing this. I can't make these decisions, or your son or whoever it might be, um, they don't have to do it. And if you didn't have anybody else, again, it's like not having a healthcare proxy. So
Correct.
now most people do check, do ask, but I do tell the clients all the time, you got to ask for
Yeah.
anybody that you are putting in any type of a position in any of your estate documents. You want to make sure that that person is comfortable doing it. It doesn't happen very often where somebody that I've come across where somebody won't do it, but it has happened every once in a while. So,
Yeah.
so you want to make sure that you talk to somebody, make sure they understand what your feelings are about these types of things,
Yeah.
and they're comfortable with it, and that's the best way to go about it.
Yeah, and I've had situations, Arthur, when I was doing direct patient work where people would put a name in and the person wasn't even aware of it and serving in that capacity. And I do want to emphasize what you said about, as important as these documents is having a conversation. It is so difficult to be put in a position of making life or death decisions for somebody that we love. We should, hopefully, if we have these decisions and we understand what the wishes are of that individual, we're not making those death decisions. We're actually following through on their wishes. I like to say, listen, it's still hard, but it's different. We should be honoring the wishes of that person. So that's part of that conversation that you're talking about too, right? Is not only are you willing to serve in the capacity, are you willing to honor my wishes?
Yeah, what you need to do obviously is have a discussion with whoever you want to put into the role of healthcare proxy, to whoever you want to put into the role of a power of attorney, whoever you want to put into any role, and make sure that and oftentimes it's a close family member. It's usually it's spouses first, as long as they haven't got to the point where they've gotten very old and are not able to handle it anymore. And then usually some other family member that is well versed in the way you think and the way you feel about things. So the conversations aren't often as difficult as you may think they are, because the person already has a lot of understanding and knowledge of what's going on. But again, it doesn't have to be a long conversation either, but it has to be, there has to be an understanding of number one, that I want you to do this. Are you okay with that? And number two, this is how I feel about certain types of situations. And it can be different for everybody. Some people are comfortable with saying, I trust your judgment, and you know me, and that's fine. And other people want to make sure that certain things that they're concerned about are taken care of. And so, yeah, I mean, you just need to sit down and talk about it.
Yeah, absolutely. It's, and I think the problem though, Arthur, is that people wait until emergency. They're having these discussions in the emergency room or the ICU. We got to get to these conversations earlier.
Yeah, another thing I always say is that everybody knows they should do this type of work, and they fully intend on doing it. But if anything comes out on the agenda ahead of it, they'll put it ahead of it and put this a little bit under the pile, because nobody really wants to talk about it.
Yeah.
But yeah, I mean, look at, you don't want to be in the situation where you're in an emergency and it's more difficult to make a determination, or you have to make a determination that you may not otherwise would have made. And then, of course, the worst case scenario that we talked about before, not being able to make a decision, and then requiring the court's involvement.
Yeah.
And I mean, I do a lot of my life is dealing with courts, and they're fine, but again, they don't respond to emergencies very quickly, because they have their own schedule and issues, and you can file for emergency appointments, but that still is not going to happen like the second that you apply for it. So
Right.
yeah, you want to you want to do this ahead of time. You want to have it set. I mean, I say to the clients, okay, we got it all done, go put it in your drawer. Hopefully you won't need to look at it for a while. Take it out every few years, make sure it still works for you, make sure you don't need to make any changes. If you do, give us a call, and and every lawyer will tell you the same thing. It's easy to make adjustments if you need to make adjustments. But yeah, I mean, the best thing is to have it done when you have the ability to fully think through and talk to people and make sure that they understand what you want, you have what you need. That's the best way to do it.
Absolutely. And make sure that you give copies to your agent and your alternate, and that you put one in your medical record. And whether it's with you have primaries and also specialists, that sort of thing, make sure that people have access to this. And when changing out, because you're right, Arthur, when you go into a medical institution, because of the Patient Self-Determination Act of 1990, they're required to ask you about one. So oftentimes what I see is that maybe the form gets handed to somebody and they might already have one in place. So when people have several of these forms flying around, these are legal documents. So I really want to make sure that people, again, the one with the most recent date is the one that would be valid, correct?
Yeah. So the newest appropriate properly signed document is always going to take precedence, and that's going to be the document that is going to be enforceable.
Yeah.
Any prior document is automatically revoked by a new document. So if you do a new healthcare proxy today, then the one you did yesterday will no longer be valid or effective.
Yeah.
And same thing with any of these documents, a will, a power of attorney, an advanced directive, anything that you sign today will take precedence over the one that you signed yesterday.
Yeah. And people need to understand also that these healthcare proxies, or they're called different things in different states, these are state to state.
They're state to state, yes, but obviously if you're in another state and you have a medical emergency, the one that you have from the state that you live in will be valid and honored in that state. So,
Yep.
so there is there's comedy between the states. So basically, whatever you do in your state is usable no matter where you are in the country.
Yeah.
I will get the question sometimes: is it good out of the country? And that I can't answer, because it all depends upon the country and the relationship with the United States and how the treaties and all that work. So, but in the United States, it's good no matter where you are.
Yeah. And as you mentioned also, and this is why I advise people, please make sure. So we're talking about the healthcare proxy, durable powers attorney, which you can just touch on for a spec, if you will, because I know we only have a few minutes left. But, why I always say to people, please don't do a durable power of attorney on your own. Please go to an attorney who's well-versed in elder law or estate planning, because the minute you sign the healthcare proxy, that does not become activated, but that can be a different ball game with the durable power, correct?
So generally, a durable power of attorney is going to be effective immediately. You can create a power of attorney that would be only effective upon incapacity, but that becomes a problem because then you always have to prove incapacity whenever you try to use it. So we don't recommend that. We do recommend that you have it effective immediately. A durable power of attorney is for everything other than healthcare. So usually it's going to be for financial type situations, but it can be, getting access to a safety deposit box. It could be for registering a car. It can be for pretty much anything that you do other than healthcare. And it is effective immediately. And I also generally will say to a client, don't give the power of attorney, unlike the healthcare proxy, don't give the power of attorney to anybody. Just make sure that somebody knows where to find it in case they need it.
Yep.
You don't want that out there flying around.
Yeah.
And so, yeah, you want to be careful about that. But it is also, again, it's an important document to have for those other decisions that have to be made, especially if you're in a position where you can't make them.
Yeah. And so also just going back now to so you went through the healthcare proxies, durable powers, and then you talked about the living will early on, and different types. Those are personal directives, and there's different versions of those out there too. 5 wishes, honoring choices. There's also, again, the Mass Coalition of Serious Illness is a wonderful resource, and there's wonderful opportunities. There's plenty of that to be able to do this. So for the time remaining too, Arthur, I just want to differentiate. So with the MOLST and the POLST, which is a medical order form.
Yeah, so those are things, and I would, along the same lines, the question I get a lot from clients is, can you do a DNR for me also, right? So again, those are all medical documents that you would do with your usually your primary care physician, in consultation with what you want, as far as if you are in any type of a situation where, are you going to be, let's revive, if you have cardiac arrest, things like. So those are medical documents. Those things you will want to talk to your own doctor about, because it's going to involve your health situation too. Maybe you have certain health issues that will lead you to make certain decisions in if emergencies come up. And so, yes, it's important. So those are important, but again, those are things that we don't do, and we can't do. Those are medical documents, but they're just as important to have as the documents that we do. Those are just things that you need to talk to again, usually it's your primary care physician about, and he or she will help you through that, and give you the best medical advice to help you make the decisions that you have to make in those situations.
Yeah, excellent, Arthur. And I know I'm going to tell you, this time goes by so fast when we're talking about this topic, and I know we need to wrap up, but could you please let people know how they can get a hold of you?
Sure. Yeah. I mean, my office is it's the law office of Arthur Skarmeas. It's in Topsfield. And you can Google me, or you can look me up. I'm easy to find. And even if you just have questions, I'm happy to talk to anybody about some questions that they may have. And feel free to give us a call, or reach out on email, or whatever you would like to do.
And we'll put that information up in a slide as well. But thank you so much for being on the program today, Arthur. This is really important information to share with the audience. We really appreciate you taking the time and doing this.
Always happy to do it, Mary.
Thanks so much. Well, thanks for joining in on Timing is Everything with Care Dimensions, and look forward to having you tune into other programs.
More than ever, it's your sanctuary. But if you're caring for a loved one with advanced illness, it can feel isolating and worrisome. Care Dimensions can help. As Massachusetts' leading hospice provider, you can count on us for guidance, medical care, and support. We follow all COVID-19 safety precautions to protect you and your family, so you don't have to delay getting the care you need. Visit Care Dimensions online or give us a call.